He's a landlord attorney. His firm supports individual landlords, apartment communities, and real estate investment firms. They deliver legal notices, file lawsuits, and defend landlords sued by tenants, as well as homeowners facing HOA or tax foreclosures. With over 14 years of experience, more than 100 excellent Google reviews, and an expert in social media education, he is a landlord attorney in Houston, Texas. So let's give him a round of applause.
Thank you, I appreciate that very, very much. And I appreciate all of you showing up. I want to talk to you a little bit about the landlording experience and how we facilitate landlords, property managers, investors all over the state of Texas. We are not exclusive to Houston. So we serve landlords all over the state. We are in Texas courts all over the state for various issues having to do with eviction, having to do with repair and remedy claims, having to do with security deposit disputes, whatever is entailed with the landlord-tenant sphere, we can handle it. So for today's topic, I want to talk a little bit about eviction. I want to start off by talking about eviction and those terrible, terrible tenants that we sometimes have to deal with. But then I want to change topics just a little bit and not point the finger so much at terrible tenants, but maybe point a few at us and the things we can do to generate the best tenants, right? Because I'm a strong believer that bad tenants come from bad property management. I'm going to get to that in just a little bit, but let's say we've got a situation where we've got a tenant that has to go. It's somebody that we know has either not paid the rent or violated the lease to such an extent that we're saying we're done, we are terminating that lease, and we are issuing notice in accordance with state law. And so generally speaking, that notice is a 3-day notice to vacate. That's a tough sounding notice, but it's exactly what the law says is what's required to terminate a lease and demand possession from a tenant. Now there are certain situations where a longer notice is needed. I'm not going to get too deep into that. If your property falls into a category where you're required to give more than 3 days notice, you're probably going to want to talk to somebody who's done this a few times and make sure you're getting your notice right, because nothing ruins evictions like terrible, tiny notice problems. So you want to get your notice right, make sure it's out there. But generally speaking, we're talking about a 3-day notice to vacate that's delivered to the tenant. And the things that landlords get right are, I want you out, you got 3 days, or I'm going to sue you. The things they get wrong are another stack of grievances that I have, because they're unforced errors. They're the kinds of things that are aggravating because it costs so much time and so much money to undo. Right? So one of those is saying, all right, here's your 3-day notice to vacate. Today is Saturday, that I'm going to sue you, let's see, Saturday, Monday, I'm going to sue you on Tuesday. Because they believe that what we mean are 3 days in the conventional sense. But that's not what the law requires. In fact, the date you deliver that notice, we refer to as day 0. It doesn't even count. So it's not 72 hours later. I serve it at Saturday at 11 o'clock, and so I can sue them on Tuesday at 12 o'clock. Huh? No, Saturday doesn't count. Sunday, Monday, Tuesday have to start and end before you can go file that eviction on Wednesday. And that simple counting error ruins evictions all the time. What's another thing that property managers or landlords get wrong? The names. Either A, they put the wrong name for the plaintiff, or B, they don't put enough defendants on that lawsuit. Simple and unforced. The lease says the landlord is 123 Housing Enterprise, LLC. But you know that Jose Vasquez is the owner. And so you say Jose Vasquez versus Tenants. Wrong. Jose Vasquez doesn't have standing in this lawsuit because Jose Vasquez probably doesn't even own the property. It's the entity that owns the property. So they are the only proper party to this lawsuit. Don't go adding information that is unnecessary. Stick to what's in the lease and file in that way. In terms of the defendants, you have to list all of the people who signed that lease, all of the tenants who remain in possession. It doesn't matter that I only talk to a metal, right? I only talk to the big guy, so I sued him, the dad. That's not enough. If mom and dad sign, you gotta sue them both. Otherwise, the court will turn you away and say, I can't sign. By rule, I cannot issue a judgment in this case because you didn't sue everybody who is required to be out. Otherwise, it would be unfair to usher somebody out who wasn't even sued for eviction. So those technical issues, these unforced errors, will ruin lawsuits. But if you get these right, if you get notice right, if you file correctly, the courts are there to help you. And let's talk about what that looks like. It's a 30 to 45 day process in the state of Texas. 30 to 45 days to get somebody out. That's not quick. So it doesn't help anybody when a tenant is saying, come on guy, I just need a couple of weeks and I will get this money in. Well, why not start the eviction process? And if 2 weeks later the money comes in, cancel the lawsuit. Easy peasy. But 2 weeks from now when the money, man, you know this, my grandma, she died and ooh, we had to spend so much money on grandma's funeral. I'm gonna need 2 more weeks. That's okay. Trials in 3 weeks. Let's hope things pick up. But that's an indication to you that this was never going to be resolved. That waiting 2 weeks is wasting 2 weeks. My policy is 7 days. If you have not received 100% of the rent by day 7, you should issue that notice to vacate. Because inevitably, statistics don't lie. Once you get to day 7, the likelihood that they'll pay the full amount of rent and next month's rent on time, practically zero. That tenant is on a snowball and it's just gonna get worse over time, I guarantee it. The ones who can fix it will. They'll do it before the 30 to 45 days have ended. The ones where it's a legitimate one time, it'll never happen again, they will come to you and say, not only do I have this month, not only do I have the late fees, I've got next month too, because I'm a person of my word. All right, I can work with that. But I got half and a bunch of excuses. That's the one that's gotta go. Absolutely, and that's the key, that you are not a good fit. That maybe from the start, this person never should have gotten keys. So yes, 30 to 45 day process started sooner rather than later because I get too many people who come in and say, Garcia, I've got somebody who hasn't paid rent for months and I don't know what's wrong with them. That's not the problem, my friend. I don't know what's wrong with you waiting more than 7 days before you do something serious. Well, they told me this and they haven't paid rent in 4 months. The problem is more localized in somebody else. That's not a bad tenant, that's bad management. So one way that we can help, if we are managing property for landlords or we're managing our own property, one way we can help ourselves is to be more proactive, to be less forgiving and more focused on running your business like a business, right? How many of you ever walk into the store, grab a 50-inch television and say, next month, you got me? All right, and you walk right out with that 50-inch television. Anybody do that on a regular basis? No? How many of you let your tenants do that on a regular, don't show your hands. Yeah. You know, a 50-inch television, that's hundreds of dollars. Well, they only had half, and I felt bad. This game is not about your feelings. It's about, did you follow the lease or didn't you? Are you a good fit or not? Because if you're not, then you don't belong here. There's a better place for you somewhere else and a better tenant for my landlord. And that's the way it's gotta be. Either they can or they can't. It's not a matter of, well, I felt bad or they're a good person. That doesn't pay the rent. It just doesn't. So either they can or they can't. And we got to stop seeing this in terms of, well, I don't want to be mean by not saying this lease is worth preserving, this property is worth protecting, and my client's bottom line is more important than their sad story. So how do you deal with these before problems ever start? We heard some good stuff about screening. I like to tell landlords, you can prevent most bad tenants from ever showing up. if they know what your expectations are. But if you don't know what your own expectations are, it's hard to find the right person. You might, for example, say, I want somebody with X as a credit score, and they're the only ones who I'm gonna let see the property. Well, guess who's not gonna see the property? People with less than X. You say, any eviction in your past? You're not coming here. You can ask for forgiveness from that old landlord. I don't forgive you for things you did, because again, the likeliest predictor of future behavior is past behavior. Okay? The jobs, yeah, if you're not picking up the phone and verifying employment, you are putting yourself or your client at risk. Pick up the phone, and don't just believe what they wrote, because Susie, my former manager, is probably her friend, right? You Google the company, find out from a third party their contact, have some standards, right? And so if you do that and we learn to only accept the best, we won't settle for good enough, right? Because good enough disappoints us every single time. But excellent tenants, I guarantee you, are out there. They are out there. We just have to find them, and we have to be willing to work to get them. Another thing that I tell, so I'm gonna give you some practical advice. So if you're managing your own or somebody else's property, there's a couple of things you gotta know. The property code has a lot of little presents for tenants. One of them, for example, is a new thing that if a tenant demands to know who the owner of the property is, and they demand it in writing, and you don't tell them within 7 days, guess what they can do? They can walk. They can abandon that lease and say, you violated my rights under the Texas Property Code, now I'm gonna leave. I'm paid up through the month, and so I'm packing up, I don't like you anymore, and you didn't follow what the law requires. Ouch, I've seen it happen. I've seen landlords upset, call me and saying, how can they do this? This does not seem right. Well, naturally, I'm gonna help you, and I'm gonna do my best to help you, but a lot of these problems can be addressed beforehand. They can be prevented with good screening, they can be addressed with proper notice, and then ultimately they can be resolved with eviction. But if you're waiting to eviction to start dealing with the problem, it's going to cost you the absolute most. You want to invest your time in good management and great screening. Okay, that's where it's going to yield the biggest result for you as your own manager or for your clients when you're managing property for others, by keeping your eye on the end. I want to prevent eviction every single time. So I'm going to be an excellent manager. The moment I get a violation, boom, I'm issuing written notice, and written notice, and written notice. Not this, well, I told him 5 times. Doesn't matter. If you can prove to the court, I wrote 5 notices of default because he won't bring his trash cans in, or he won't keep his dog on a leash, or he broke one of the doors and now refuses to pay for that repair. Notice, notice, notice. Guess what you have? An excellent case where you can prove to the court you acted with diligence and the tenant violated that lease. By setting this up, you set yourself or your client up for maximum success. Quickly get rid of people who do not fit well on the property and take care of the ones who do. A flip side of inspection isn't just finding out the bad, it's finding out the good and learning how to nurture good relationships with excellent tenants, right? Talking to them, being there, giving a little extra, making sure that when it comes down to renewal, maybe if it's around the holidays, you give them a little something, right? You anticipate that renewal's coming up, and maybe say, you know what, my landlord was talking about an increase, I talked him down, we're gonna keep the rent exactly where it is. Or he wanted 10%, we talked him down to 5%. How about you sign a renewal, right? Fostering good relationships with excellent tenants is another way that you defend and protect and preserve your business so that it maximizes its profits. So deal with bad tenants for sure, but also deal with those excellent tenants and make sure if you're managing these kinds of properties that they know you value them and that you guys are working together for a maximum return. They enjoy your property, you enjoy them paying for it, right? That's a working relationship. Foster those. People who can't do that, they gotta go, and they gotta go fast, sooner rather than later, because every day they're there costs you money. So I hope you see that both, yes, eviction is out there as an option, And it should not be an option that you consider the last possible. It should actually be something you go to quickly. But if you're having to do it, it's because something along the way broke. That's something that can be fixed so that you don't need to rely on eviction except in the absolute worst cases. By setting yourself up for success, I guarantee you're going to do much, much better in this landlording game, and I wish you all the best of luck. And I guess we're going to open it up for questions if people have them.
Yes.
If you find yourself for the very first time filing an eviction or contemplating an eviction, or maybe you filed one or two that went easy peasy, but this one's a doozy, I've got some news for you. For those of you, particularly in the state of Texas, I have an eviction course. It's called Texas Eviction, step by step from start to finish, where I'm going to guide you through the whole process. I have a video course with 6 modules and a 39-page ebook that walks you through everything from notice to filing, even to judgment. And so I'd like for you to take a look at this. If you're interested in purchasing this course, you can go to attorneyeg.com/EV for more information.
So you need to post it on the door, or if you live out of state and you have a property. So how do you do it?
Don't ever post a notice on the outside of a door. I don't know if that's what you meant, but never on the outside.
Okay.
There is a way to do it. I tell all landlords, avoid that way. Avoid it because it's so easy to get it wrong. If instead you have a key, you are free to open the door, say, hello, anybody there? No? Okay, I'm gonna tape the notice to the inside of the main entry door. If you're gonna put it on the door, that's the only way to do it right. You put it on the outside, there are 8 ways for you to get it wrong, and you will get it wrong. So don't do that. But my recommendation for all notices to vacate is that you send them through regular and certified mail. You say, Garcia, that seems like overkill. I promise you it is the best method and the one the courts love the most. It does not get argued because you show up with a receipt that says 1 regular, 1 certified, and you've got a tracking number. And what we recommend is you do the following. You track the certified letter, they go together. They're in the same bag with that letter carrier, and he shows up and he's, I got a letter for Joe. No? No Joe? Hello? Okay, well I'm gonna leave this regular one right here in Joe's mailbox, and I'm taking this other one with me. And when that gets recorded on the tracking, it gets recorded as an attempted delivery. Well, guess what? That letter's never gonna get in Joe's hands, never. But that log as attempted delivery is message to everybody that the regular letter got mailed on that day. That's day 0, 1, 2, 3, on day 4 or after, you file. And now you can prove to the court delivery. Now, if Joe was there and it is marked delivered, boom, even better. Because you can show up to the court, proof of delivery. Because I've had landlords who testify and say, I gave notice to them on date X. And the tenant testifies and says, you didn't give that to me. In fact, I remember you handed it to me and I said, oh, I don't want to take that. And I never took it. It fell to the floor. You remember? That's the way I remember it. Now, did that happen or didn't it? I don't know. But if the judge finds your landlord 50% believable and that tenant 50% believable, you know who wins? The tenant, every time. Because the burden of proof is more likely than not that it happened. If you're equally believable, it didn't happen. That's a problem. But if you show up with a receipt, regular and certified mail, boom, it happened. And confirmed delivery. And that argument wins every single time. And so, yes, deliver notice. There's no such thing as delivering too much notice. Did you know that? You can deliver inadequate notice. You can deliver insufficient notice. Let's say instead I took that and instead of opening the door and then fixing it to the main entry door, I went and I put it on their chair. I know where they sit at the table. Their chair right there with a post-it note, read me, and then I walk out. Is that good service? You probably already know it's not. Doesn't count. Same house, same open door, but because I didn't affix it to the main entry door, I violated the law. And the court will not reward me for giving bad notice. But if I regular mailed it, certified mailed it, emailed it, posted on the inside of the door, the outside of the door, put it on the windshield of the car, taped it to the garage door, put it on the dog's collar, all of that counts, I guess. But because you did regular and certified, it doesn't matter. Because you did at least one way that's absolutely perfectly right. All the other ones are irrelevant. They may speed up the process and may inform the tenant sooner, but they don't make it more correct. You just have to get one correct method down and you win, right? But if you have no probable, or if you have no proper method of delivery, then you lose. And that's important for you to know.
But they want to have an early termination and they just move out.
Mm-hmm.
What happens?
You are allowed to shoot them. So what happens in this situation? Because it happens a lot. It happens all the time. And I saw first year, oh yeah, that's good. Okay.
Still have.
So let's talk about what the lease means and what early termination is. So because we sometimes get this misunderstanding because of the TAA lease, which is an apartment lease. Great lease. The TAA lease does sometimes offer a reletting or an early termination clause within the lease, because apartment complexes tend to get new people in all the time. It's a lot easier as opposed to single family houses. So if you're using the Texas Realtors lease and you have single family housing, there is no early termination clause in that document. And that's there for a very good reason. I know in my lease, the one that I draft and sell to clients, I don't feature an early termination. I think it's a bad idea for a single family house. And here's why. It's hard to predict this crazy market, and it's hard to predict when the tenant is going to leave. Because we know that a tenant that skips out in the month of August is going to be easier to replace than the tenant who skips out on December 20th, right? Much harder to find people, that time of the year, whereas right now it's hot. I could probably rehab that place and get somebody in there in 10 days, potentially, right? It also depends on where you're located and what amenities you have and the condition of the property, but all things being equal, it's going to be much easier in the summer than in the winter. That being said, how do you resolve this? So you have a tenant who says, let's first start off with the one who says, I would like to terminate early. I bought a house. I'm not going to live here anymore. You can't force me to live here. I will leave. But I'd like to work something out. And they say, so here's what I'm thinking. I'm paid up through the end of August. I close on August 28th. And so I'm going to move out at the end of this month. Now, we're in the middle of August right now. But I tell you what, you can keep that deposit and we're square, right? Yeah, everybody? Mm-hmm. Maybe. And so the calculation for any landlord in that situation is, what will my losses be? If the tenant does everything they say they're going to do, move at the end of the month, before the month ends, and I'm going to get access to that unit on September 1st. How long is it going to take me, and what's it going to cost me? Because that landlord's probably going to have lost rent. They're probably going to have to pay somebody like one of you, to go find a new tenant. And so those are real costs that usually exceed the value of 1 month rent, or what would likely be that deposit. So can you work out? Well, we believe that the total losses will be about a month and a half, 6 weeks of rent, plus the fee that I'm going to pay to somebody else to find a new tenant. So that's about 2.5 months. So yeah, it would be 1.5 months rent, plus you waiving the deposit, assuming there are no damages on the property. Yeah, that's a good estimation of what I believe it'll be in terms of losses. And yeah, you could reach that settlement with them, and maybe upon them vacating, they leave an empty house, they turn in the keys, they give you an additional month and a half and waive their deposit. That sounds like a pretty decent deal. But if it doesn't work out for that landlord, and in fact it takes 3 months to find somebody, that could be complicated. So you run a little bit of a risk. But typically that's not the case, especially in the Houston area. The market's pretty good. So you can, if you can predict well enough, you can, again, prepare for that. But when they just run off, now you got to ask whether they left $1,000 worth of damage or $10,000 or $20,000 is all going to come into your computation. You think they caused this amount of damage, but they're saying, no, I'm entitled to a full refund. Or maybe there's a repair and remedy matter, right? Maybe something's gone wrong and you don't know if you have to pay $10,000 to fix it. Or they use the M word, right? Mold freaks out landlords. And it really shouldn't. It really shouldn't, for one very basic reason. We live in a very moldy city. There's mold everywhere. I guarantee there's mold in here. Guarantee you there's mold in here. But are any of us going to get sick from it? No. Because very little of the mold that exists around us actually makes us legitimately sick, right? And because there is so much mold, if someone does get sick, how do we know they got sick from the mold in your house and not the mold anywhere else in this very wet, moist, warm, dank, smelly city, right? It's everywhere. We don't have the best air. Yeah, so people get sick, you know, they get bronchial stuff all the time, and it doesn't necessarily have to be you. Don't freak out if somebody uses the M word. Yes, ma'am.
How much it costs an eviction process or the?
It depends.
Yeah.
It depends on a number of factors, but I give you basic data. So for a Harris County eviction, we charge a $1,500 retainer plus filing fees. If it's one defendant, it's about $135. So we ask for a $1,635 initial retainer here in the Justice Court, which is the first level. If there's an appeal, you can expect about twice that amount of additional costs, right? Or if you hire us on appeal, you can expect about $1,500 to $1,700 for representation on that level.
You put the notice, and when you need to file this, when you do it, or you do the notice and you do everything?
So it's going to depend on how experienced you are. Because I would recommend, if you've never delivered a notice before or you've never filed before, you need to know what filing is like before you ever prepare a notice. Just like you need to know what management is like before you ever sign a lease, right? And so you want to be a few steps ahead of the game. Because I always argue, if you come to me too late, we're talking every month is another $1,500 or $2,500 or $3,500 of lost rent. Don't risk that. Early is always better than late. So in terms of what do I know for sure, I got notices down. Okay, we don't need my help for that. But if you suspect after this notice I might have to evict, and I've never done that before, then as you're sending or before you send that notice, get that help. Because you don't want to delay 2-3 weeks, because that's real money for you or your client.
As well, is that judgment, that once you get the judgment, you win the judgment, can you go after the tenants for that?
Yes.
Okay.
But again, we have that same thing that I talked about earlier.
Yeah.
Do you know where they are and do they have the capacity to pay?
It's probably never going to get it, but you can
Potentially, but there are ways to get some of it, or there are ways to protect the landlord from accumulating additional losses. There are rules on appeal that can require the tenant to pay into the court registry during the process, but you have to demand and enforce those rules, and if you don't know how, you end up losing month after month after month when you didn't have to.
You sell the lease, right?
Yes.
You have a lease that you sell. How much is that, and is it a subscription or is it like a one-time fee?
It's a one and a,
Yeah.
so it's $650, and we'll tailor the lease to you, whether you want a short term or a long term, whether you want, whether it's multifamily or single family, whether you allow smoking or non-smoking or pets or no pets. All those variables, we'll go through those with you and design the lease for you that you can use over and over and over again. You'll get the Word version of it, and you can tailor it to your letterhead or to your whatever. You want to reformat it in whatever way you want, you're free to do that. We just recommend you don't change any of the substantive terms.
What do you have multiple types of leases that you do? Some short-term, some mid-term, some long-term?
You can modify this lease to accommodate any one of those situations.